Yapalingana. Welcome to the University of Tasmania's Island of Ideas online public lecture series. Mina, Maggie Walter Mina, Palawa Luchuwita, Withi Waranti Kani, Mapali Milathina, Mina Tunapri, Palawa Nigimpi Nigampi Tikara. Hi, my name is Maggie Walter. I'm a Palawa Tasmanian Aboriginal woman from Luchuwita, Tasmania, and I acknowledge that we are meeting on Aboriginal land, and I pay my respects to our elders past and present. And I'd like to introduce Professor Greg Lehman, the Pro Vice Chancellor Aboriginal Leadership at the University of Tasmania, to give the welcome to country.
Thanks, Maggie. Yatuacha mina palawa waranda palawa mina loitianina waranda loitianina. In offering a welcome today, I'd firstly like to honour the Monina people, who are the traditional owners of the western shore of the Derwent River around the port of Hobart, where I'm speaking to you from. The Monina knew this place as Nipaluna. None of us contemporary Tasmanian Aboriginal people can welcome you on behalf of the Monina, as none of us can count them as our ancestors. There's a reason for this. The First Nations living on the western side of the lower Derwent and Huon rivers were wiped out by an epidemic of a coughing disease just a few years on from the British setting up their camp at Nipaluna. So it's unavoidable that this year's celebration of the International Year of the World's Indigenous People will occur against the global backdrop of the COVID-19 epidemic. This crisis is a necessary reminder of the experience of Indigenous people across the world since the beginnings of modern European colonial expansion. Often it's a common experience that brings people together through shared understanding. Just as nations around the world are being brought together in a common struggle to manage the impact of this current coronavirus epidemic, we have an important opportunity to reflect on the experience of Indigenous people over the past 400 years as they experience the impacts of influenza, smallpox, and dozens of other infectious diseases introduced by colonial powers in their competition for economic and military influence. While the settings may be different, the impacts on our ways of life are analogous. Each experience of a major epidemic leaves lasting impacts on a society's economy and their culture. For most Indigenous peoples across the world, the impacts were much more intense than the disruptions and mortality that we're currently experiencing through this COVID-19 crisis. And this was certainly the case for the Monina. It's also important to acknowledge that these impacts are not contained by the past. As the United Nations emphasises in its discussions around the 2020 year of the world's Indigenous peoples, they say Indigenous communities already experience poor access to healthcare, significantly higher rates of diseases, lack of access to essential services, sanitation, and other key preventative measures, such as simple things like clean water, soap, and disinfectant. This results in Indigenous people being amongst the most vulnerable to the current pandemic here in Tasmania and across the world. Against such a devastating background, can treaty making remain a priority? As we begin to understand the relationships between pandemics and disruption of environmental systems, we can also start to recognise the importance and urgency of properly acknowledging the custodial rights of Indigenous people over their lands. In April of this year, the heads of 16 French research organisations raised the alarm on links between pandemics and ecosystem degradation. They noted that the ability of viruses to jump species is significantly enhanced by habitat destruction and fragmentation, biodiversity loss, and illegal wildlife trafficking. The solution they propose is important. They say, focusing on the interdependencies between functioning ecosystems, sociocultural practices, and the health of human, animal, and plant populations taken together is what's important. These are the very defining characteristics of Indigenous life worlds, and the very same qualities of caring for country that our First Nations emphasises to our calls for formal recognition of our rights in the systems of governance of our nation states, in our constitutions, and in our legal frameworks. In many ways then, we can consider our current COVID-19 crisis as a reminder of the urgency of treaty making with Indigenous people, perhaps even evidence of its necessity. So in welcoming you today, I ask that you remember this every time COVID is mentioned. If you do this, you'll begin to understand how important the issue of treaty is for Aboriginal people. Thank you, and I wish you well in your discussions today.
Thank you, Greg. Thank you very much. Just to go back to the Island of Ideas, I mean, this lecture series is designed by us at the University of Tasmania to keep the ideas flowing through this period when we're unable to host live public events. And it fits in with our overall pattern where we present, every year we present hundreds of lectures, forums, seminars and workshops free of charge for our students, alumni and the wider community. These are a really important part of the university's role and why we're hosting forums such as this one today. Before we move on to our speaker, I just want to go over a couple of housekeeping notes. So please check that your microphone, camera, chat function and raised hand function have all been disabled so our speaker is not interrupted. But we do encourage you to actually ask questions as you think of them, and you can do this by typing them into the Q&A function that you'll see on your screens down the bottom. Q&A, very clear. We'll go back to those at the end of the lecture and answer at least some of those questions before we complete today. So today's lecture is a special addition to the program, and the university is very pleased to partner with Reconciliation Tasmania to present their second International Day of the World Indigenous Peoples lecture. The inaugural lecture was held last year and was delivered by two alumni of the university, the wonderful Dr. Patsy Cameron and the equally wonderful Professor Tim McCormack. I would now like, it is my great pleasure in fact, to introduce today's speaker, Emeritus Professor Mick Dodson AM. He'll be talking today on treaty, and that's a topic for which we are very due a discussion here in Lutruwita, Tasmania. So Mick is a Yawuru man and a title holder from the Broome in Western Australia, but he's also, most of you will recognise him, he is indeed one of the most recognisable faces, inclusive of his hat, in Australia. So there are plenty of reasons for that recognition. He's contributed enormously to this country over the last lots of years. So I'm just going to outline a few of his activities and achievements. And believe me, I'm only just touching on a few of those things. So he's formerly the director of the National Centre for Indigenous Studies at the Australian National University. He's Professor Emeritus of Law at the ANU College of Law. He completed a Bachelor of Jurisprudence and a Bachelor of Laws at Monash University, when worked with the Victorian Aboriginal Legal Service from 1976 to 1981, when he became a barrister at the Victorian Bar. He then went on to join the Northern Land Council as Senior Legal Advisor in 1984 and became Director of that council in 1990. During this time, he was also assisting the Royal Commission into Aboriginal Deaths in Custody, serving as counsel for the Northern Territory and Western Australia. He's been a member of the Victorian Equal Opportunity Advisory Council. He was the first Aboriginal and Torres Strait Islander Social Justice Commissioner and was what was then the Australian Human Rights and Equal Opportunity Commission, now just the Australian Human Rights Commission. He's a former member of the New South Wales Judicial Commission and a former Special Commissioner with the Law Reform Commission of Western Australia. Professor Dodson is also prominent internationally. He was co-deputy director of the Technical Committee for the 1993 International Year of the World's Indigenous People. And in 2005, he commenced a 6-year appointment as a member for the Pacific of the United Nations Forum of Indigenous Issues. This, the United Nations Declaration of the Rights of Indigenous Peoples came out of that work. And this, of course, this declaration was overwhelmingly adopted in 2007 by the United Nations General Assembly, and somewhat a little bit later by Australia in 2009. In 2009, Professor Dodson was named Australian of the Year by the National Australia Day Council. And in 2011 and 12, he was the Gough Whitlam and Malcolm Fraser Harvard Chair of Australian Studies and a visiting professor, Harvard Project on American Indian Economic Development. So even just that little brief is a very impressive resume. But these are just the things for which Professor Dodson is known and recognised. Beneath that is a whole layer of contribution which goes on in the background. So just for a small example, I've had the honour of working with Professor Dodson since 2004 on the Longitudinal Study of Indigenous Children project, which works with a large cohort of Aboriginal and Torres Strait Islander families to really develop the idea of how Indigenous children grow up strong. It's now in its 13th wave of data collection, and Mick is not only the chair of the steering committee, a role he's held steadfastly for the last 16 years, but he was also largely responsible for its instigation and at getting a separate study for Indigenous children rather than just Indigenous children being a subset of the longitudinal study for Australian children. So post his academic career, Mick has taken up the challenge of being the Northern Territory Aboriginal Treaty Commissioner, and it is from this expertise that he addresses us today. So ladies and gentlemen, I introduce our speaker, Professor Mick Dodson.
Nadi Gurjan, Nayanilawan, Michael Yawuru, Janoburu Rubibi. Hello everyone, my name is Michael Yawuru and I'm from Broome. Thank you, Maggie, for that kind introduction. I feel exhausted now. All the things I've meant to have done. And thank you to Greg for the welcome to country, and please, I extend my warm greetings to the traditional owners and my respects to them from that part of the island of ideas. The title of my talk today is essentially about treaties. In his National Press Club address last year, the NAIDOC week, Mr. Wyatt, the Minister for Indigenous Australians, said a truth-telling process would allow Australians to reflect on the place of First Nations people, and that the telling has to happen at all levels across Australia. He noted that the Bringing Them Home report opened the records of child removals, which was painful but necessary. He said that truth sets a person free, and they are thereby willing to listen to the truth, to find common ground to walk on. And regarding treaty, Mr. Wyatt said it's important for states and territories to take the lead in treaties. And I trust in saying that he was not implying the Commonwealth can wash its hands of treaty making nationwide. The federal parliament, in my view, must be involved. And I think as a nation, we're at the crossroads when it comes to bringing the social and economic gaps between Indigenous and non-Indigenous Australians. And as we sit at those crossroads, despite many well-meaning efforts, we still see a very uncertain future for Indigenous Australians, which in turn creates uncertainty for non-Indigenous Australians. And to resolve the uncertainty, this country needs to take a different road than the ones previously travelled. And to understand the uncertain future and to reinforce the inadequacy of past policies, you need to look no further than the Closing the Gap agenda. More than 10 years on, the Prime Minister's report of 2019 advised that only 2 of the 7 targets were on track. And the coalition of Aboriginal and Torres Strait Islander organisations recently entered a partnership with the Council of Australian Governments to progress the next phase of closing the gap. And I think that's a good start in doing things differently and travelling on a different path. However, service delivery is only one part of a different way of doing things and making a sustainable difference. A more comprehensive approach is to look at treaty or treaties. I'm looking at a number of things in this address, but firstly, exploring the question, why a treaty or treaties? And secondly, what are some of the challenges in achieving treaties in the Northern Territory and Australia? And finally, why truth-telling? I think before we address these questions, we must be clear about what we mean by treaty. Essentially, a treaty is a settlement or agreement arrived at by treaty or negotiation. And a treaty gives rise to binding obligations between the parties who make them. It acts to formalise the relationship between the parties to the agreement or agreements. Now, there's a bit of a myth floating around that treaties can only be made between countries. This is not the case, as evidenced by modern treaty making between governments and First Nations peoples in Canada and New Zealand. Treaties are not restricted to agreements between countries. We can negotiate treaties between states, nations, governments, and people. And treaties are an accepted way around the world as a way of reaching a settlement between Indigenous people and those who have colonised their lands, for example, New Zealand and Canada. When we think of modern treaties with Indigenous peoples, we think about three key elements. Firstly, recognition that Indigenous peoples are distinctive and differentiated political communities from other citizens within the country, state, territory. So at its heart, a treaty is a political settlement. And the settlement, secondly, the settlement is achieved by an agreement, negotiated as equals in good faith, and in a manner that's respectful of each party's equality of standing. And finally, the government recognises or establishes structures of culturally appropriate governance. Those structures have to have powers of decision making and control, and resources must be provided to make them happen. So why a treaty or treaties? Well, unlike Canada, the United States and New Zealand, Australia has never formally recognised a treaty with Indigenous people. And it wasn't until the Mabo decision that the government recognised the property rights of Aboriginal and Torres Strait Islanders, with the exception of Australia. The British recognised those rights in all other of their colonies. And the basis of British sovereignty up until the Mabo decision relied on a ruling in 1889 of the Judicial Committee of the Privy Council. The Privy Council said Australia was not occupied by conquest or cession, but rather was, to quote, practically unoccupied without settled inhabitants or settled law at the time it was peacefully annexed. And this is essentially the doctrine of terra nullius, which the High Court rejected in the Mabo judgment. But the Mabo judgment hasn't delivered a just settlement of the legitimate historical grievances of Aboriginal and Torres Strait Islanders. These claims are not only defined in terms of meeting the physical needs of Indigenous peoples, but they also have to, for Aboriginal and Torres Strait Islanders, they have a moral dimension. And as I've already noted, also a political one. Because treaties in the modern sense are not merely designed to address the horrible impact of Indigenous peoples, on Indigenous peoples, of the ongoing colonisation as a moral issue. Yes, as I've said, it's also a political settlement. So better informed government policies or programs of service delivery, which focus on health, housing, education, welfare, etc., will never meet the moral component. And to cater to the moral imperatives, there has to be a recognition and acceptance by governments of two necessary truths. Firstly, Aboriginal and Torres Strait Islander peoples have been injured and harmed throughout the colonisation process. And just recompenses is owed. And secondly, the status of Aboriginal and Torres Strait Islander peoples as First Peoples and the distinctive rights and special status based on prior occupation at play from that has to be recognised. So intensive government programs aimed at bringing about equality with other citizens will not of itself provide justice for Indigenous Australians. And some still believe that these measures are a form of compensation for past injuries. However, this is not the case due to two key issues. Firstly, the adequacy of compensation, and secondly, the rights of Indigenous Australians to self-determination. Moreover, I believe treaties will form, in a sense, a grand overarching grand reconciliation action plan without the assimilationist undertone. And Mr. Wyatt has said that the truth-telling will free us. So why do we need to resort to truth-telling? Well, I think Australia is required as a nation to deal with our unfinished business. Our nation needs to deal with our colonial past and the impact on First Nations. Every Australian must know of our shared history and its deadly and ongoing impact on the Indigenous First Peoples of this land we now share. So just allow me now to take a short, brief incursion into history. Essentially, this is what happened. The discovery and settlement of Australia occurred in stages. Lieutenant James Cook, as he then was, had instructions in 1768 to discover what was then known as New Holland. I mean, the Dutch had been here almost 200 years before Cook. Cook landed at Botany Bay on the 29th of April 1770, and by 22 August 1770 had purported to take possession of the entire Australian east coast on behalf of the British King. And the first fleet arrived on the 26th of January 1778, and Governor Phillip raised the British flag on the 7th of February 1788. And the colonisation of the continent had begun. Now, territories designated terra nullius during the colonisation period were pretty much a rarity. Wherever there were people with some form of social or political organisation, the European colonists generally acquired territories by conquest or cession. And when Captain Cook departed England to discover Australia, his instructions said, and I quote, "You are also with the consent of the natives to take possession of convenient situations in the country in the name of the King of Great Britain. Or if you find the country uninhabited, take possession for His Majesty by setting proper marks and inscriptions as first discoverers and possessors." Well, Cook ignored the natives cut an inscription in a tree, raised the British flag, violated the international law of the time, and disregarded the instructions of his superiors. Consent of the natives was never sought or obtained. Now, I think a treaty or treaties can fix that problem. Cook seemed to regard Australia as terra nullius on the assertion that Aboriginal people lack political organisation with federal law. This assertion relies on the erroneous view that there was or had to be, in European terms, one single Aboriginal nation, which is absolute nonsense. There are over 500 nations with long-established law and political systems. Indeed, the Lower Murray tribes joined in a confederacy. And that was all that was required in international law at the time. Australia was an exception to British behaviour elsewhere, particularly in Africa. The High Court decision in Mabo, although rejecting terra nullius and recognising native title, did not, and said it could not, challenge the foundations of present Australian sovereignty. As the court said, it was a question not justiciable in municipal courts. So how can the court have accepted the validity of Aboriginal and Torres Strait Islander rights to land, but not uphold rights of governance? Why the inconsistent allegiance by the court to the occupation settlement fallacy? Indeed, who is the sovereign for the Aboriginal laws and customs native title claimants must rely on to establish their claim? Interestingly, here in the Northern Territory treaty process, the Northern Territory governments accepted that First Nations of the Northern Territory never surrendered nor ceded their sovereignty. They also agreed, and I quote from the Barunga Agreement, that Aboriginal people, the First Nations, were the prior owners and occupiers of the land, seas and waters that are now called the Northern Territory of Australia.
That's all your enrolment information and form that we've got to fill in for Wednesday.
Sorry, I've got a voice coming in over me. I don't know what that is. It's gone now. Secondly, the First Nations in the Northern Territory were self-governing in accordance with their traditional laws and customs. And finally, that there had been deep injustice done to Aboriginal people of the Northern Territory, including violent dispossession, the repression of languages and cultures, the forcible removal of children from their families, which have left a legacy of trauma and loss that needs to be addressed and healed. Now, the importance of these concessions in the by the Northern Territory government means that the First Nations peoples of the Northern Territory and the government don't need to argue about these things. They're already agreed. And constitutionally and legally, the agreement met between the Northern Territory Land Council chairman and the Chief Minister of the Northern Territory has no legal, international legal import. So whatever the High Court has left us with post-Mabo as to what is now the foundations of sovereignty of the Australian native states is somewhat of a mystery to me. The sovereign pillars of the nation state are arguably, at the very least, a little legally shaky. And a treaty with the blacks may or can fix that problem. These questions aside, we need truth-telling to appreciate what horror and devastation most of Indigenous Australia has gone through for well over 2 centuries. And the past is part of the unfinished business. So what am I talking about when I use the phrase unfinished business? Well, the Council for Aboriginal Reconciliation, in their final report, did not use the term unfinished business when dealing with this issue. Rather, it chose to use perhaps a more politically friendly term, unresolved issues. In Appendix 3 of their report, the Council defined unresolved issues to mean any issue, whether already identified or identified through the processes of this Act, remembering that the Council approach was for a legislative framework, that is an impediment to achieving reconciliation until it's addressed, including but not limited to the recognition of the rights to equality, the protection of Aboriginal and Torres Strait Islander cultures, heritage and intellectual property, the recognition of Aboriginal and Torres Strait Islander custody law, and a comprehensive agreements process for the settlement of native title and other land claims, regional autonomy and constitutional recognition, to end the quote from the report. So what we are talking about when we use the term unfinished business is the yet to be met legitimate grievances of Aboriginal and Torres Strait Islanders arising directly from the colonisation by the British and Britain's successors and the ongoing consequences of that colonisation. It's about confronting the legacy of the past and realigning the relationship between government and us and the people of Australia. This process is truth-telling. There are outstanding matters going directly to a proper relationship between Indigenous and non-Indigenous Australians and the future of that relationship. And if we're talking about treaty making in a new Australia, these outstanding matters must be central to that process. Their resolution by agreement is essential to lasting reconciliation. And identifying what we're talking about, I don't think is a difficult part. Most of the work has already been done. Itemising or particularising the unfinished business is not the hard part. No, our libraries, archives, research institutions are replete with the evidence of our bloody past. We need to establish the framework within which we are to proceed and how we might address unfinished business as the first step in a treaty process. In thinking about unfinished business, we need to address the principles that might underlie a treaty in broad national terms. And they should firstly include recognition of Aboriginal and Torres Strait Islander people as the first peoples and the distinct rights that flow from this, and secondly, agreement to the necessary reforms for a more just society and the setting of national standards to inform state, territory or regional treaties and any other constructive agreements. Perhaps the preferred approach is for a national framework model, which allows the treaty making at a national, state, territory-wide, regional or local basis. Excuse me. Moreover, it also allows the treaties that could be comprehensive, deal with multiple or single issues, or merely address the specific local issue. So maybe you're asking, why should we do it this way? In other words, why do we need a treaty or treaties anyway? Well, there are many things about the British invasion which are uncontested or ought to be. In the first place, the invaders, their descendants or past governments have never formally recognised our rights. And secondly, our rights have been affected by a lopsided relationship with the newcomers. They saw us as primitives with no rights and no concept of civilised customs. A treaty or treaties could have recognised and protected Indigenous rights and led to a just constitutional basis for Australian Federation. We were completely overlooked as a relevant party in the formation of the Australian Federation. If a treaty had been in place and constituted by the principles I've noted above, the structure of federation would no doubt have incorporated Aboriginal rights and position in the federal system. And a national treaty can fix our racially discriminatory constitution. I've already mentioned that the reasonable basis for a treaty process above, but namely that Aboriginal and Torres Strait Islander societies have been injured and harmed throughout the colonisation process, and just recompense is owed. But those issues should not be seen as the only basis. It's important to realise that a national framework treaty or agreement would allow Indigenous communities and other local, regional, state and territory stakeholders to sign treaties in line with a national minimum standard, which each other at those levels. One option for these minimum standards would be to adopt the standards contained in the United Nations Declaration of the Rights of Indigenous Peoples. And this declaration has this golden thread running through it, the golden thread of free, prior and informed consent, and has 4 key themes that should set the scene for minimum standards. And they are self-determination, participation in decision-making, respect for and protection of culture, equality and non-discrimination, finally, including the right to be free from racial discrimination. So, finally, as I said earlier, and perhaps above all, the treaties process will deliver the ultimate certainty to the relationships between Aboriginal and Torres Strait Islanders and the rest of the country. My paper goes through what's happening in the Northern Territory, but I think I'm out of time now. So I can provide the paper to the organisers of this talk. I'll keep talking, we're going to run out of time for any discussion. So, and perhaps, I can address some of what's happening in the Northern Territory in the discussion. So, Galia, I'm done. Anyone there?
Yes, Mick.
Yeah, I'll finish, Maggie. Thanks.
Thank you very, very much. I think, yeah, reconciliation just cannot proceed until the unfinished business of the Australian nation state is addressed, and Aboriginal and Torres Strait Islander people, our rights, our truth-telling, our recognition of our sovereignty is central to that. So thank you very much. I wish we had some applause to bring, but we don't. The downside of Zoom. I'd like now to introduce Mr. Bill Lawson, who's going to join Mick on the Q&A panel. And can I remind the audience to put your questions up in the Q&A section, and we will get to those after I introduce Bill. You just type them in. So Bill Lawson AM is a recently retired engineer, and he's worked across Australia in both local government and Indigenous sectors. And from 2011 to 2012, Bill was a Tasmanian representative on the Prime Minister's expert panel for the recognition of Indigenous Australians. In 2006, he was also awarded an Order of Australia for his development of the National Youth Assistance Initiative, the Beacon Foundation. And I think most people in the audience will know Bill. So in 2015, Bill was appointed to the Board of Reconciliation Australia, replacing the retiring Fred Chaney, and provided a Tasmanian voice for the first time on Australia's peak reconciliation body. In 2017, Bill established Reconciliation Tasmania, of which he is now co-chair, and which currently has a membership of over 350 Tasmanians who are committed to reconciliation. So if I can invite Bill to be part of the Q&A panel, and I'll open up the Q&A questions. I've got one very long one to start with, so I might sort of go down and start with a relatively straightforward. So the first question, what are your thoughts, and I guess this mostly goes to you, Mick, on what is happening in Victoria in regard to working towards a treaty?
I've had a close look at what's happening in Victoria. I mean, it's a matter for the Aboriginal people of the First Nations peoples of Victoria to work out what they want to do. What we've recently issued a discussion paper that can be found at our website. Just treaty NT, just type in to your search engine treaty NT oneword.com.au and you'll find the discussion paper. We're taking a suggested self-government approach, so that won't be necessary unless the First Nations determine for themselves to have a voice or assembly to the territory government. But what's proposed is Aboriginal government speaking directly, government to government, with the Northern Territory government, or indeed the federal government for that matter. If they want to come into an assembly of First Nations of the Northern Territory, they're free to do that. But we're not having that as a central part of what we're proposing as the model in the Northern Territory. If people want to do that, that's their business. We're not going to preempt it. Sorry.
So, Bill, we've got another question here that asks if you can speak at all to the idea of treaty making in Tasmania.
Yes. Can you hear me all right? Because I've turned my camera off because the internet, I'm getting a message, is unstable. So probably best just not to have my ugly face, just hear my voice. So the question is, could you repeat the question, please, Maggie?
Yes, so there's, after Mick's just talked about treaty in NT in Victoria, they want to know if you have any thoughts about the specifics of treaty making in Tasmania, in the Truthtelling.
Yes, a lot to say. I'll try and be brief. I think it's important to recognise last year's IDWIP address by Patsy Cameron and Tim McCormack, which largely centred on the case. I'd be interested to hear Mick's comment on this when I finish. Largely centred on the case of saying, have we already got a treaty or indeed treaties on foot as a result of the negotiations between Manaligena and George Augustus Robinson as an agent of Governor Arto, of course, of the Crown. And there was a strong case put by Patsy Cameron about that last year. And there's been a lot of comment in the last 12 months about perhaps we have a treaty on foot, and certainly Reconciliation Tasmania have had discussions with both Premier Hodgman and Premier Gutwin to that effect, as well as opposition leader White and Greens leader O'Connor. And there is seeming to be quite a deal of recognition of a degree, at least a degree of validity there, if not a strong one. And the other point to be made there is that Professor McCormack, in his supporting address to Dr. Cameron, or Patsy Cameron, was dealing with the issue of is it still relevant given the passage of time and the statutes of limitations and stuff like that. And he was emphatic and indeed gave lots of examples of the passage of time being irrelevant to the currency of such an agreement. And he gave examples, Mick, of Canada and, well, in telling a pair of addresses last year. So to come back to the question, Maggie, Reconciliation Tasmania has rather pursued the relevance of this since over the last 12 months. And indeed, one of the reasons we were keen to get Mick to do the address today was to try to get a perspective, a wider perspective that might help that process happen. So that's a long-winded answer, but maybe it would be good if Mick, if you'd like to make some comment on that, because I know we sent you the documents, so you're aware of it. I'll be quiet.
Yeah, I don't have a particular view about it from a legal standpoint, but it's a good starting point, I think. I mean, my understanding of what happened is that, like around the world generally, with European colonisers, they made promises that they didn't keep. And the Indigenous people tend to honour for their part, their side of the bargain, but the colonisers generally ignore their commitments to such arrangements. But it's somewhere we could start, I guess, from Tasmania's point of view. It could be expanded into a full-on proper arrangements like those being made in New Zealand and British Columbia and Canada, which are happening as we speak. So we can learn a lot from what they're doing in Aotearoa and British Columbia. Really updating treaty commitments made 2 centuries ago.
I've got another question here, which is slightly sort of a challenging one, is what do you think that governments are most afraid of when engaging in the treaty process, or to get them to engage in the treaty process?
I think that there's some sort of fear that sharing power or devolving power to Aboriginal people is somehow going to bring the nation state asunder, which is nonsense. The jurisdiction of, for example, the Northern Territory, the jurisdiction about the Territory's government's recognition that Aboriginal sovereignty hasn't survived forms the heart of the negotiation for a treaty. What are the limitations? Can we negotiate? I say, nothing should be off the table. We're only confined by our imaginations or lack thereof. But if we sit down honestly as equals across the table, and it's going to take time, we can sort through these things. We're big enough and old enough and mature enough to do this. Any resistance to, because of perceived threats to the stability and unity of the country are unfounded. We need to be mature enough to deal with our past and get on together with our future, seeking to undermine the nation state, the members of the federations, including the territories, in their governance. We're saying that what most affects our lives on a day-to-day basis in particular is a matter for us. And a matter for our decision making. As they say here, in the territory, not in Darwin or Canberra, we should be making those local decisions. We deal with these issues on a day-to-day basis. We're the best place to deal with resolving our own issues, not someone from outside.
I've got another question that's been asked by a few people, which is how, if you're a non-Indigenous Tasmanian, how can you support or advance the treaty making process?
Write to your local politician, join in unity with Aboriginal Tasmanians to fight the cause. The more voices in favour of treaty, the better. Also, don't be afraid to look at your history. Part of the treaty, the truth-telling process is to inform an uninformed public, broader public, to the non-Aboriginal public, non-Torres Strait Islander public, about this history. The 1889 case that purported to given license to the British colonisers to peacefully annex the country is, just BS, essentially. It's just not the truth. That's not what happened. The Aboriginal nations, First Nations around the country, were devastated by colonisation. Thousands upon thousands of Aboriginal people died as a result of colonisation. And many of them died from deliberate, organised murder, to put it brutally. Dispossessed their land, language and culture. Copped a pretty shocking depletion, taking kids away. These things still haunt us today, and we need to address them. And as with the famous, not famous, but a prominent Canadian Aboriginal woman, Carol Blackburn, said, well, we should see treaties as a marriage, not a divorce. We don't, Aboriginal people aren't saying, well, we want to separate from other Australians. We don't. We want the opportunity to exercise our self-determination, particularly power over those decisions that affect our very existence. Those distinct political communities, among other things.
Thanks, Nick. Look, we're just about out of time. So, Bill, can I ask you, so thank you for everybody who put in questions. We couldn't get to all of them, but we've covered what we could. Bill, in asking you to do the vote of thanks, could you also answer that last question about what non-Indigenous people can do to advance the idea of treaty? And then thank you everybody for coming, and I'll hand over now to Bill.
Yeah, sure, Maggie, and thank you for that question. It is such a vitally important question. And I think there are so many non-Indigenous Australians who, as they are progressively becoming aware of the truth, are really wanting to do something about it, not just talk about it. And I think that the whole reconciliation movement across Australia, including, of course, Reconciliation Tasmania, has got a particular focus on how we might bring that forward. And it is no fluke that Reconciliation Tasmania has arranged these lectures this year, as well as last year, focused on the issue of treaty. It is no fluke that we're having discussions, ongoing discussions with our political leaders, and it will be no fluke that we make progress. So if people want to be involved in it, I would encourage them to join in Tasmania, join Reconciliation Tasmania, and of course anybody who might look at this from any other part of Australia to join the reconciliation councils in their states, because they exist in all states and it's a common agenda. I think it is a very clear high priority for the whole reconciliation movement. So that would be my encouragement. So as we draw to an end, it is my responsibility to thank you, Mick, for being willing to join us today and to share with us, with your calm and informed and rational demeanour, which characterises you as well as your hat, and helps us all to understand that it is possible to have some calm and rational discussion with the First Peoples. And you are such a prominent leader in Australia and have been for so long in that capacity. We're indeed privileged and grateful that you've agreed to meet us today. And it is a Sunday when all's said and done, on this International Day of the World's Indigenous Peoples. And indeed, you've had a pretty strong hand on that tiller too, in terms of establishing IDWIP. So thank you, Mick. It has been a pleasure to listen to you, and I'm sure you've stimulated a lot of thinking with people, but you've also done it in a manner which gives them a chance to be calm about it and be thoughtful about it. So again, thank you, and thank you to everybody for joining us today.
It's been a delight, Bill. Thank you for that.
So thanks, everybody. Just to conclude, this afternoon's talk will be available soon as a video and podcast via the Islands of Ideas website. It's now on your screens, that slide there. And we're going to be continuing with an upcoming online public lecture and forum also on your screen. So I strongly encourage you to continue the discussion by registering for these talks. So we look forward to, as the University of Tasmania, to continuing the ideas debate and discussion in Tasmania. So thank you very much for being part of this event, and Wallaka, good afternoon.